vicarious liability action, and my clients responded to that action by filing a motion to compel arbitration, attaching an arbitration agreement signed by Ms. Gonzalez's son, Robert Gonzalez. I will refer to them as Luetta and Robert since they have the same last name for clarity. The trial court denied our motion to compel arbitration. The trial court made two findings that we believe were in error. The first was that we, as appellants defendants, did not establish a valid arbitration agreement. The court stated, quote, "There's enough doubt in my mind as to how this document was signed as to whether it is true, valid agreement to arbitrate." The second finding was that the plaintiff, appellee, had created an issue of fact with regard to Robert's authority to enter into the arbitration agreement for Luetta, and found that Robert lacked both implied and apparent authority to enter into that agreement for Luetta. We believe each of those findings were in error, and they should be reversed for three reasons. First, under Tennessee statutory law and common law, the defendants, appellants, made a prima facie case of a valid arbitration agreement when we presented a written agreement, signed and written. Once we did that, the burden shifted to the appellees to provide a contractual defense or to otherwise invalidate that arbitration agreement by a preponderance of the evidence. Plaintiff, however, did not attempt to carry this burden of proof and did not show by the preponderance any contractual defense or grounds to invalidate, and the plaintiff's appellees do maintain that they in fact have no burden to invalidate that agreement. And three, we believe those two findings and errors should be reversed because the defendants had the burden of proof to prove Robert's authority. That was our burden, and we did in fact prove that by preponderance of the evidence. This court reviews a denial of a motion to compel arbitration, much like a bench trial de novo with no presumption of correctness. Findings of fact, you can review with a presumption of incorrectness unless the preponderance says otherwise, and you can make your own conclusions when reviewing documentary evidence, such as depositions and transcripts. At the hearing of this matter, only depositions and transcripts, not live testimony, was before the court. It is undisputed, Your Honors, that on November 1st, 2019, when this arbitration agreement was executed by Robert, that he was in the room with his mother at Sycamore Shoals Hospital. It is undisputed that he visited that room specifically for the purpose of signing admission paperwork for signature of Princeton. It is not in dispute that Ms. Gonzalez Luetta was competent. It is not disputed that she knew he was signing paperwork for her to go to signature of Princeton. She could hear him and see him and the signature representative with that paperwork the entire time. She was engaging in physical therapy, but she could see and hear at all times. And Robert does not deny that it is his signature on the arbitration agreement. It is also not denied that if the arbitration agreement is enforced, this dispute will be governed and fall under the provisions of that arbitration agreement. Again, Your Honors, the burden here for both the plaintiffs and the defendants is preponderance of the evidence, more likely than not. Black letter law, specifically 10 Code Annotated 4750-112A, which is titled Contracts to be Enforced, says, quote, it creates a rebuttable presumption that all contracts in writing and signed by a party to be bound shall be prima facie evidence that the contracts contains the true intention of the parties and shall be enforced as written, provided that nothing herein shall limit the right of any party to assert any other rights or defenses provided by common law or statutory law in regard to contracts. Though it's not controlling, it is persuasive. The Eastern District of Tennessee, in the Heath case, evaluated Tennessee law, and they found a proponent of an arbitration agreement meets their burden and a prima facie case by introducing a signed written agreement. And Raines, Court of Appeals case, says a proponent has to show a valid agreement, and then the burden shifts to the other side to raise a defense or to otherwise invalidate that agreement. Instead, our trial court shifted that burden to the defendants. It's clear. He says, I don't think the defendants have shown a valid agreement. I have doubts as to how this agreement was signed. Plaintiff never undertook the burden and maintains it was not their burden. So at best, plaintiff here has created doubt about how a signature was signed. Creating doubt by its very definition does not make something more likely than not. How doubt was cast, because I cannot say that it was in furtherance of a defense or an invalidation, was Robert's testimony, which is quite contradictory about how he signed the agreement. And one part, and it's cited in our brief, Your Honor, he says, I signed it, then they came back and I signed a second time. He doesn't remember if there were two tablets, one the signature read Pat, one he had. He doesn't remember if there were also hard copy documents. He doesn't remember the hospital calling him the day before saying, you're coming in to sign your mom's paperwork. He doesn't remember any of that. His memory is quite poor on this issue. And we want to be really respectful to Mr. Gonzalez. He is a veteran. He's a wonderful human being. But he admitted he has PTSD, which does affect his memory. So his memory does bear very respectfully mentioning here. When evidence is contradictory, it cancels each other's out unless it is corroborated by other evidence. Plaintiffs' appellees offered no evidence to corroborate Robert. They did not depose the physical therapist who was in the room when these documents were signed. They did not depose the social worker who spoke to Robert Gonzalez the day before saying, you're coming in to fill your mother's paperwork out. None of that proof was put forth. They didn't request the DocuSign information that provides how electronic documents are signed and the security procedures behind that, how those documents are timed. Nothing whatsoever to corroborate Robert's testimony. On the first time on appeal, the police have brought up the circle of assent doctrine. That is a doctrine that is not appropriate in this case, Your Honor. First, it's waived because it was brought up for the first time in appeal. And the Brown case they rely on is wholly inapplicable. The Brown case essentially was about a provision hidden in a document where even had someone read it, it was very likely they were not going to find it. And basically, the Brown put the burden on the proponent of the arbitration agreement to say, prove you bargained for this agreement. That also, the folks, even though we're in Tennessee, we're going to have to arbitrate Nevada. Our case is not like that. Our case is a freestanding arbitration agreement with all the rules of arbitration, how it will proceed, what says, you do not have to sign this, and these are the rules if we do this together. Brown is unapplicable. Again, creating doubt does not carry your burden. And again, plaintiff doesn't believe they have a burden. Next, Your Honor, we carry the burden that Mr. Gonzalez had implied authority. As outlined extensively in our brief, they had a history of Miss Gonzalez, who was very close to his mother. He referred himself as a mother's boy. She trusted him. She knew he would do what was best for him. He took her to doctor's appointments. He signed her discharge instructions. When she executed a power of attorney, she named her daughter, the plaintiff, and Robert as an alternate because she trusted them.
So he was not the primary power of attorney?
He was not, Your Honor. And when we mention the power of attorney, Your Honor, it's to show that she trusted him. It is not applicable here because she was not incapacitated in any way. She was in the room knowing what Robert did and was fine with it, which was her right to be fine with it. But the history, implied authority can be found by circumstantial evidence to show the intent of the parties. Why would Ms. Gonzalez tell Sycamore Shoals Hospital that my son is the one that's going to come sign my paperwork for Princeton if she was not, by her actions and the preceding circumstances, named him as her emergency contact if she was not granting him authority? And finally, we believe Robert had apparent authority. Apparent authority is a little different, Your Honors, right? It's really about what a third party is saying. Has three elements. One, Louetta acquiesced in Robert's exercise of authority. She sat right there and watched him sign the documents. She could hear him. She never objected. She never expressed displeasure at him doing it. Second, did the appellants, the defendants, have a good knowledge?
Why not she sign it herself then?
Your Honor, and that's the point of apparent authority. Had she said, I do not want Robert to sign this, I want to sign this, we could have handed it right to her and we wouldn't be here. But she sat there and made her choice, which was absolutely her right to do, to let her son sign this document. And this case is completely distinguishable by other apparent authority cases that this court and other courts, these arbitration cases vex this court, they vex the litigants, they are very challenging. I know you all are probably tired of them, but completely different than Ratteri, Allenbrook, Farmer, and Manley. All of those cases, the resident was not in the room. They were whisked away, and a family member signed from them, and the attorneys tried to argue apparent authority. Our Miss Gonzalez, Louetta, was in the room. She knew what she was doing. So we ask that the court reverse the lower court's ruling, find that plaintiff did not carry their burden on enforceability, and find that we did carry our burden as to authority. Thank you.
Thank you. You have your rebuttal time. Yes.
Morning, Your Honor. Leslie Muse of the Knoxville Bar, here with Grant Mitchell on behalf of Lisa Honeycutt and the family of Louetta Gonzalez. Before I get into my prepared argument, I would like to correct a few things that I perceive as misstatements that have just been made to the court.
It's your time. You follow it. You do it in the way you want to.
Thank you, Your Honor. It was stated to this court that it was undisputed that Robert Gonzalez visited the hospital that morning for the purpose of signing admission paperwork. There's nothing in the record to support that. In fact, what the record says and its appendix at page 56 of his deposition, appendix 31, he was asked, was this described as admission paperwork? And he says no. He was told that a random person called him and asked him to come to the hospital to sign some paperwork to transfer his mother after uncomplicated knee surgery to a rehab facility. So we believe that is an incorrect statement based on the record. Secondly, it was represented to this court that it was undisputed that she knew he was there to sign paperwork for her. That is also incorrect. In his deposition, and it is appendix at page, it's the appendix at 31, page 54 of his deposition, lines 17 through 19. Did she know you were there to sign paperwork? And he says, I don't know. His testimony, along with the physical therapy records, are that she was in a lot of pain and she was undergoing physical therapy at the time, in the room, maybe not even aware of what was going on. The third thing I'd like to address is it's been presented to this court that this was a signed document. We do not concede that this signature constitutes a signature on a document within the purview or the scope of TCA 4710-1028, which defines a signature as including the intent to sign a record. The testimony in this case, and we believe actually that Robert Gonzalez was an excellent witness. If we were going to question the credibility or the memory of a witness, it would be Ms. Housewright, who administered or was the signature representative present with Mr. Gonzalez. Also, just for the record, we take issue with the characterization of his memory. Appendix 21, pages 14 and 15 of his deposition, he addressed his memory. He does have PTSD, but he described it after being in active combat of being triggered by sights and sound and noises that sometimes take him back to a combat situation. He said when that happens, it doesn't happen very often, but it's ugly. But it's not a circumstance where it impairs his memory on a day-to-day basis. So we believe that characterization is incorrect. And also, if we're going to talk about the memory of the people involved, let's compare that to Ms. Housewright. At the time of these events, she was in training. She'd been doing this job 3 weeks. She had absolutely no recollection of anything that occurred. She has no firsthand knowledge, gave no testimony as to Louetta, Robert. She was asked about her training on DocuSign. She said there was a video. She was not able to say whether it was one video or 20 videos. She was not able to say whether the training was 30 minutes or 2 days. She had no recollection of anything of use whatsoever.
Ms. Muse, let me ask you this. I'm familiar with DocuSign. I've done it myself. And so as I understand it, you create an initial signature, and then when you're electronically reviewing whatever you're signing, you tap, and then it will populate that line with your signature, and then it will go down to the next one, and you tap, and you tap, and you tap. In this case, it's my understanding that Mr. Gonzalez says, I don't recall doing any tapping. I recall doing a signature. And Ms. Housewright can't say who did the tapping. Is that a fair assessment?
Yes, Your Honor,
Okay.
you're absolutely right. And I think this is actually the most interesting and provocative issue before the court, and I think you're going to be seeing a lot. DocuSign has a great functionality and reliability, when handled through electronic communications. I have received emails with the DocuSign link. I then have to enter into the document and create my own signature. There are going to be a lot of cases before you, quite frankly, where DocuSign is used to obtain electronic signatures in in-person situations. And not to be too cavalier about it, but it's a red flag. It's quite sketchy. While it serves a purpose, in this circumstance, Robert Gonzalez was told, we need a signature to transfer your mother to Sycamore Shoals. As part of their argument on implied authority, they had talked about the prior course of dealing. Well, a signature for transportation was consistent with their prior course of dealing. Ms. Honeycutt, or Ms. Gonzalez, prior to this, lived independently, did her own banking, attended her own medical appointments, made her own appointments. Her children only helped her when she needed to be driven somewhere. So him being asked to sign off on something for transportation or transfer was appropriate. There are other, and he says, I provided one signature, it was on a tablet. I did not click through, and I believe it's at page 59 and 73 of his deposition, which is also part of the appendix. Affirmatively, I provided one signature.
Was there a line for witness to the signature?
Pardon?
Was there a line for a witness to the signature?
In looking at the documents, Ms. Housewright also signed this arbitration agreement. And I should note that Ms. Ballinger has referenced the document itself, the arbitration agreement. Find it here in my pile. I would rather read directly from it. So on the...
Is it in the record, though?
It is.
Okay, then we could see that. We'll report ourselves.
So on the third page of that document, which I apologize, oh, here we go. Wrong file. I'm so sorry, Your Honor. The agreement to informally arbitrate, on the last page, which is the page at issue, Ms. Housewright also signed as the facility representative, but not necessarily as a witness. Importantly, on that document, up at the top, there were places that she could have designated the authority. We know the power of attorney wasn't applicable. There's a place up at the top and it says check all that apply, and this is page 713 of the record. The resident, while able, gave me oral authority to make decisions for her, not checked or initialed. I've handled the resident's legal and business affairs for blank years. His initials were placed there, but no designation as to the number of the time. The resident signed a written document allowing to make decisions for him or her, not signed or addressed, placed there even by Ms. Housewright. Then also no conservator, no guardian, no surrogacy. None of that is indicated on this document. And so when they first filed the motion to arbitrate, we asked the court to deny the motion based on the ambiguity of the documents alone. They relied on two documents in that first argument, what they call a post, which is at page 710 of the record. And on that document, it says that it was discussed with the patient and then someone placed Mr. Gonzalez's signature on this. While we don't believe that corroboration is necessary, because that would be a contract offense, and what the court held is that there was no contract ever formed for two reasons: lack of consent and then also lack of authority. It's important here that the post only says that they discussed it with the patient. That in no way gives or reflects any authority for Robert Gonzalez to act on her behalf. The second document that they relied on is this arbitration agreement, where they could have indicated the authority for him to enter into it, but didn't. Ms. Housewright testified that at this point in her training, she was not explaining documents to families. She was not doing that. She didn't feel competent to do that. That typically that was her mentor who was doing that. But her mentor wasn't present in the room, according to the only person who remembers, who is Mr. Gonzalez, who said there was one signature representative. Interestingly, what the defendants did not rely on and never filed with the court, but which we provided, and this is between pages 905 and 906 of the record, but it does not have a page number on it. And I believe it's volume 7, it's page 56 of 165. So in the medical records that we received, there's a document called Declaration of Merit of Housewright. It appears to be an affidavit type document that they want to support the authority or to make the arbitration agreement more binding or more reliable. However, Ms. Housewright says, on or about 11/1/2009 at 10:19 a.m., I presented a written arbitration agreement for signature to Luetta Gonzalez. She does not say Robert, she says Luetta. And then coming down, it says check one statement that applies, and she is checked. The resident who appeared and acknowledged that he or she was capable of understanding and able to make his or her own decisions at that time signed the arbitration agreement, him or herself. And then there's a statement, I declare that this information is true and correct, and she has signed that document on November 1st, 2019. So our initial position was they haven't proven the existence of an arbitration agreement. They provided one electronic signature of Robert Gonzalez. All of the signatures say 10, 17, and 58 seconds. So while we don't think we have to corroborate, the record itself corroborates that because the times are all exactly the same. His testimony was not ambiguous. He did not say that he signed twice. He was adamant that he signed once, but giving a narrative description of things, he repeated himself. He signed, we're doing physical therapy. I signed the document and then I left. He did not say, I signed a second thing, and there is no time other than 10, 17, 58 identified with any of these signatures. And this is not just going to be an issue for the court in healthcare decisions. Anecdotally, a friend of mine was car shopping and was told by the person in person, sign this right here and give us your electronic signature, and then we're going to put together your paperwork for the car deal. He was like, I'm not just going to give you a signature to put on a bunch of random documents that you've never seen. So we believe that the trial court was correct in both of the instances, although we think the court could agree with him on one, disagree with him on another, and still affirm him. The first is this issue that no agreement was formed. The defense has referenced the Federal Arbitration Act, which talks about consent. We've cited the Supreme Court cases in our brief. The Tennessee law talks about mutual assent. We've also briefed circle of assent, which isn't waived. It's a legal doctrine argued to support the court's ruling. It's not an issue that we're asking the court for relief on. Then, of course, 4710-1028 says a signature has to include an intent to sign the record. Robert Gonzalez intended to sign a piece of paper to allow his mother to be transported. So we think all of these things, consent, circle of assent, intent to sign, it's all part of the same thing, which is whether there was a meaning or an intent by the parties to reach an agreement, and there was not. The trial court should be affirmed on that. He was absolutely correct. The second issue is one of authority agency, which is well briefed. There's a line of cases. The court is well familiar with those. My time is winding down. So I would like to call to the court's attention the documents or the things that weren't referenced, that are fact specific to this case. At page 903 of the record, there's a document titled Appointment of Surrogate that is blank. Luetta Gonzalez could have appointed him as her surrogate, did not. And then finally, Luetta actually signed her own admission documents on November 5th once she was at the hospital or at the rehab facility. And there's a document starting at page 893 of the record, Admission and Financial Agreement. It is a 4-page document, and it addresses payment, rights, responsibilities, all kinds of things. And on page 896 of the record, it says, this agreement, together with the information and documents in the resident handbook and admission information executed by both parties, represents the entire understanding between the parties and supersedes all previous representations, understandings, agreements, oral and written, between the parties. So first, we think the trial court was correct that no agreement was formed because there was no mutual assent. Second, we think Robert Gonzalez did not have the authority, actual, age, apparent, implied, anything. And in fact, the arguments that he did are contrary to the records of the defendant themselves that do not document that authority. But third, we think the court could disagree with the trial court on both of those and say, based upon 896 in the record where when Luetta was finally asked to sign documents, this works as a revocation or rescission because this is everything. And it doesn't include an arbitration provision. And then one last point that I would like to make is that TCA 6811-901 deals with the minimum rights of admittees and residents to nursing homes. Subsection 23 of 6811-901 includes the right to exercise the resident's own independent judgment by executing any documents, including admission forms. Nothing from the defense, document-wise or testimony-wise, has addressed the issue of why Robert was asked to sign this in the first place. Your Honor asked it, Judge Lauterbach asked it, I asked it in deposition, no one has an answer for it.
Thank you. I think you've completed your point. Thank you very much. Yes, ma'am. Your rebuttal.
Thank you, Your Honor. Your Honor, as to the statements as stated were undisputed, we will rely on our briefing and our citations of the briefing for each of the statements I've made to corroborate those statements. Your Honor, again, they had a burden to invalidate or bring a defense to the arbitration agreement. The law is we had to show a written and signed agreement, which we did. They did not undertake the defense of that agreement. Ms. Muse mentions Robert's testimony where he uses the word not transfer, but transport. Mr. Gonzalez was in the U.S. Army and he was in the Transportation Corps. And so that word made a lot of sense to him. And it's in our briefing as well. And I asked him, what do you mean by that? And he said, well, that's my word. I said, did the signature representative use that word with you? No, I don't remember what they said. So he does not recall what the signature representative said. He remembers them going over some pamphlets. My husband hates it when I say pamphlets, and some other information about the facility. He does not remember exactly what they said, but transport was his word. Your Honor, counsel brings up the declaration and the post. Our view of those is they're absolutely consistent. The declaration is a document that signature personnel fill out to memorialize what happened in the room. Miss Housewright was in training. She was brand spanking new. And she put on there, I explained it to the resident. I think that makes a lot of sense with Luetta Gonzalez in the room, hearing and seeing. I do not find that document contradictory. Also, Your Honor, if Ms. Housewright's testimony was not sufficient for plaintiffs' appellees to meet their burden, her preceptor and trainer, who she said was in the room with her, could have been deposed and could have said, yeah, I was in there too, and I was the one that explained everything. Robert says he thought there was one person in there in his deposition, and then he mentions the physical therapist later in his deposition. So Robert's testimony was contradictory on these issues, and the plaintiffs did not take their burden to substantiate or corroborate that testimony. Your Honor, one more point about residents' rights. It is absolutely critical, and healthcare facilities maintain the dignity of their residents. They have a right to make their own healthcare decisions, and Louetta did. Her son was there, who she trusted, and he signed the documents for her. Doesn't matter what we call them, admission documents or whatever we want to call them. We'll rely on what the testimony says. He knew he was there. He was called the day before, said to come and sign these documents. He was called by Sycamore Shoals Hospital, not Signature Princeton. And he came, and she knew he was signing documents on her behalf. We do ask that the trial court's 2 findings be reversed. Thank you for your time.
Thank you very much. I want to thank both the attorneys for your presentation. Your case now has been submitted to this court. You should receive our opinion and our judgment on this case within a reasonable period of time. The attorneys may be excused at this time. Thank you very much.